Assalamualaikum warahmatullahi wabarakatuh and hi everyone. So today we would like to present about the types of crimes. Subject is English for Law, DSU 2243 and our lecturer's name is Sir Khairul bin Abdul Ghani. And this is our group's member. First, Nur MAIZATUL AKMAL binti AZMAN, PID 22021. Nur HAZWANA binti Muhammad IZMAN, PID 22035. SAFIYYAH binti ZURAIMI, PID 22156. And the last one is Nur HAZIQA binti Muhammad REPAI, PID 22037. So, I will explain about the definitions, types of crimes. Crimes can be classified in various ways based on their nature, severity and impact. Below are the main types of crimes grouped by their categories. So, let's move to our first presenter for today.
Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, my name is Nur HAZIQA binti Muhammad REPAI, PID 22037. Okay, first of all, my team will present about types of crimes. Firstly is personal crimes, which have two, murder and rape. Okay, first, definition of murder. Murder is the unlawful killing of another person with the intent to cause death or serious harm. It is considered a serious criminal offense and can be classified into first or second degree depending on intent and premeditation. It differs from manslaughter, which involves less intentional or reckless conduct. Okay, this is example for the case of murder. The name of this case is the death of Zulfarhan Osman Zulkarnain. The murder of Zulfarhan Osman Zulkarnain was a criminal case involving views that occurred in the early morning hours of 21 and 22 May 2017. The case involved the victim, a student at the National Defense University of Malaysia, Zulfarhan Osman Zulkarnain, who was repeatedly beaten and burned with a steam iron by a group of fellow students over the accusation of stealing a laptop. Zulfarhan was seriously injured and died on 1 June. The case later gained national attention as an extreme bullying incident in a dormitory environment. The case generally ended 3 years later on 2 November 2021, when the final verdict was finalized, with 6 suspects initially sentenced to 18 years in prison for wounding without intent to kill, Section 330 of the Penal Code, while 17 suspects were sentenced to 3 years in prison for wounding, Section 34 of Penal Code, with sentence starting that day. However, with an appeal hearing held, the case was reclassified as murder, with all 6 suspects convicted and sentenced to death in July 2024. Okay, secondly is definition of rape. Okay, what is rape? Okay, rape is non-consensual sexual intercourse or sexual acts. Refers to sexual activities that occur without the consent of one of the individuals involved, often through force, threats, or coercion. This is commonly known as rape or sexual assault and is a serious crime. Next, the case of rape. Harvey Weinstein, American film producer. In 2019, the Washington Post reported that Harvey Weinstein reached a settlement agreement with sexual abuse and harassment victims totaling $47 million. Over 30 women claimed Weinstein either sexually harassed them or engaged in other forms of sexual abuse. According to the settlement terms, Winston did not have to admit to any wrongdoing. Still, the announcement is a significant milestone in a very public affair over several years. Harvey Winston was convicted in New York in February 2020 for sexual assault and rape and was sentenced to 23 years in prison. He has lost his appeal. He is now slated to face a trial over charge of rape and sexual assault sometimes in 2022 in California. As of right now, he faces 4 counts of rape and 7 counts of other types of sexual assault. He is still facing dozens of civil suits filed by actors. Okay, next drugs crimes. which is drug possession and drug trafficking. First, drug possession. Definition of drug possession. Drug possessions refers to the act of having illegal or controlled substance in one's personal possession or control. The laws surrounding drug possession vary depending on the country or origin, but generally it refers to possessing drugs without legal authorization, such as prescription drugs without a prescription or illegal substance like marijuana in areas where it's illegal, cocaine, heroin, and other things. Consequences of a drugs. Consequences of a drug possession conviction can include fines, imprisonment, mandatory drugs counseling, or probation. Probation. However, some jurisdictions may offer diversion programs, treatment option, or reduced sentence, especially for non-violent offenders or those caught with small quantities for personal use. The legal landscape is changing in some parts of the world, particularly regarding marijuana, where some regions have decriminalized or legalized its use for recreational or medical purpose. Okay, the case is Alma Nudo Atenza versus PP and another appeal, 2019, 3 MLRA 1. The central issue in the present appeals was on the constitutional validity of Section 37A of the Dangerous Drugs Act 1952, which appeared to allow the use of double presumption to find possession as well as trafficking for a charge under Section 39B of the DDA. But both the appellants in these two appeals were charged before and convicted by two different trial judges for drug trafficking under Section 39B of the DDA. In the appeals, the issue to be decided here, inter alia, either leave from the federal court to challenge the constitutional validity of Section 37A of the DDA was required in accordance with Section 4 of the Federal Constitution. Whether Section 37A of the DDA contravened the principle of separation of powers in the FC and whether Section 37A of the DDA violated Arts 5 and 8 of the FC Federal Code. Held the first appeal on the defense of Inon's career, the Court of Appeal agreed with the finding and conclusion of the trial judge. It was held that it was not enough for the first appellant to merely assert the absence of knowledge. If and when the circumstance arose suspicion, the Court of Appeal opined that it was incumbent upon the first appellant to make the necessary inquiries. Accordingly, the appeal of the first appellant was dismissed. The second appeal, the Court of Appeal also agree with the learned trial judge on the lack of credibility to the story that the second appellant traveled to Bahrain for holiday using funds supplied by some. Indeed, the Court of Appeal found the defense of second appellant was a burden. It was incapable of casting and reasonable doubt in the prosecution's case or rebutting for presumption of knowledge on the balance of probabilities. The appeal was therefore dismissed. Drug trafficking. Drug trafficking refers to the illegal trade or distribution of controlled substances such as cocaine, heroin, methamphetamine, marijuana, and other drugs. It involves various activities, including the production, transportation, sale, or possession of illegal drugs, typically for profit. Drug trafficking can occur at different scales, from small street-level deals to large-scale international operation. Case Nagentran K. Dharmalingam. He was a Malaysian drug trafficker who was convicted of trafficking 42.72 grams of heroin in April 2009 upon entering Singapore from Malaysia at Woodlands checkpoint with a bundle of heroin strapped to his thigh. Nagentran confessed to committing the crime but gave statements claiming that he was ordered to commit the crime out of duress by a mastermind who assaulted him and threatened to kill his girlfriend and his family. He also claimed he did so to get money to pay off his debts before he later denied of any knowledge of the contents of his bundle. Nagentran was sentenced to death by hanging in November 2010. However, his execution was put on hold due to a moratorium placed on all hangings in Singapore pending judicial change of the mandatory death penalty laws, which consider and approve the imposition of life imprisonment, imprisonment with or without caning for drug traffickers who were couriers or had mental illness. Okay, that's all from me. We will go to the next presenter.
Thanks to previous presenter, next I will continue with the sexual crimes, which is the sexual assault and child abuse. Sexual assault happens when someone either touch another person in a sexual manner without consent or makes another person touch them in a sexual manner without consent. It includes unwanted kissing and the touching of someone's genitals, breasts, or button. A young woman stands inside a house holding a hot drink in a mug and looking off the side. Her expression is serious. The term sexual assault is commonly used to refer to any form of sexual violence or abuse that involves physical contact between the perpetrator, person responsible, and the victim or survivor. However, under English and Welsh law, form of sexual violence and abuse that involves penetration of someone's mouth, vagina, or anus are considered different crimes. Rape or assault by penetration. Sexual assault can involve the touching of skin, clothing, or the use of something else to touch skin or clothing. It is a serious crime that carries a maximum sentence of 10 years in prison. And any form of sexual assault can have a serious and lasting impact on the victim or survivor. No one ever deserves or asks for sexual assault to happen. 100% of the blame, shame, and responsibility lies with the perpetrator. This is case about the sexual assault. Muhammad Firdaus Abdul Rashid, 47 years old, Melaka. A teacher was charged in the Aikaro Session Court today for committing physical sexual assault on a female student last July. The accused, Muhammad Firdaus Abdul Rashid, 47 years old, however, pleaded not guilty and requests to be tried as soon as the charge were read before Judge Rohatul AKMAL Abdullah. According to the charge, the accused is accused of physically sexually assaulting a 16 years old female student by hugging, kissing the cheek, and holding the victim's stomach at 12:30 p.m. in the sick room of a school in the Melaka Tengah district here on July. Following that, the accused was charged in accordance with Section 14 of the Sexual Offence Against Children Act 2017 and convicted could be sentenced to up to 20 years old in prison and caning. In addition, the accused must be imprisoned for a maximum of 5 years and subject to a minimum of 2 lashes. The court then allowed bail of 9,000 ringgit with security and the condition of not disturbing the victim and reporting to the police station once a month. The prosecution of the case was carried out by the Deputy Public Prosecutor Muhammad Ali Hussein and the court on November 25 of November as the date for the submission of documents and the appointment of a lawyer. Child abuse. Child abuse can be categorized into 4 different types: neglect, emotional abuse, physical abuse, and sexual abuse. A child may be subject to one or more forms of abuse at any given time. Abuse and neglect can occur within the family, in the community, or in an institutional setting. The abuse may be someone known to the child or a stranger, and can be an adult or another child in a situation where abuse is alleged to have been carried out by another child. You should consider it a child welfare and protection issue for both children, and you should follow child protection procedures for both the victim and the alleged abuse. The important factor in deciding whether the behavior is abuse or neglect is the impact of that behavior on the child rather than the intention of the parents or carer. The definitions of neglect and abuse presented in this section are not legal definitions. They are intended to describe ways in which a child might experience abuse and how this abuse may be reconciled. The example case of child abuse, which is Siti Bainun, the case of Siti Bainun. On the 20th of August 2021, Siti Bainun was charged in the session court here and one charged as the person responsible for taking care of a 30 years old girl with Down syndrome had neglected that by causing the child to suffer physical and emotional injury. On 25 November 2021, the founder of Rumah Bonda was charged again in the same court on another charge of persecuting the same youth. On 3 May 2023, the woman who was active in charity work was sentenced to 12 years in prison after being found guilty of the two charges and ordered to serve her sentence immediately after rejecting an application for a suspended sentence. The accused is also required to sign a good behavior bond for a period of 5 years with a surety including a 5,000 bond as an additional sentence, in addition to performing 200 hours of community service within 6 months after the end of the prison sentence with the conditions imposed. On May 2, the High Court found that he remains guilty and rejected Siti Bainun's application for the execution of the prison sentence to be postponed after finding that there were no special or unusual circumstances to allow this. So the next point is political crimes about the treason and espionage. So next is treason. Treason is the crime of attacking state authority to which one owes in allegiance. This typically includes such as participating in a war against our native country, attempting to overthrow its government, spying on his military, its diplomats, or its secret service for a hostile and foreign power, or attempting to kill. It has to state a person who commits treason is known in law as a traitor. Historical in common law countries, treason also covered the murder of specific social superiors, such as the murder of a husband by his wife or that of a master by his servant. Treason against one's monarch was known as high treason, and treason against a lesser superior was petty treason. As jurisdiction around the world abolished the petty treason, treason come to refer to what was historically known as high treason. At times, the term traitor has been used as a political epithet regardless of any verifiable treasonable action. In a civil war or insurrection, the winners may deem the loser to be traitors. Likewise, the term traitors is used in heated political discussion, typical as a slur against political dissenters or against officials in power who are perceived as failing to act in the best interests of their constituents. In certain cases, as with the Dolco Belgians, stat in the back mind, the execution of treason towards a large group of people can be a unifying political message. So this is case about the treason, United States vs. Wilberger. In 1820, Chief Justice John Marshall stated that treason is a breach of allegiance and can only be committed by someone who owes allegiance. In Shinohara. At 1949, an enemy alien resident in Guam was found guilty of treason for acts done while the enemy nation occupied the territory. The Kramer Court reversed a treason conviction, concluding that the defendant's disloyal intent must be evident from the witness acts themselves. The court also stated that the government would have to prove that each overt agent actually gave aid and comfort to the enemy. Next is espionage. Espionage, spying or intelligence gathering is the act of obtaining secret or confidential information intelligence. A person who commits espionage is called an espionage agent or spy. Any individual or spy ring a cooperating group of spies in the service of government, company, criminal organizations, or independent operation can commit espionage. The practice is clandestine as it is by definition unwelcome. In some circumstances, it may be legal tool of law enforcement, and in others, it may be illegal and punishable by law. Espionage is often part of an institutional effort by a government or commercial concern. However, the term tends to be associated with state spying or potential or actual enemies for military purpose. Spying involves cooperation is known as industrial espionage. One way to gather data and information about the target or organization by infiltrating its rank. Spies can then return information such as the size and strength of enemy force. They can also find dissidents within their organization and influence them to provide crucial information or to defect. In time of crisis, spies steal technologies and sabotage the enemy in various ways. Counterintelligence is the practice of thwarting enemy espionage and intelligence gathering. Almost all sovereign states have strict laws concerning espionage, including those who practice espionage in other countries, and the penalties for being caught are often severe. So this is case about the espionage. Robert Philip Hansen, the 18th of April 1944, was an American Federal of Investigation (FBI) agent who spied for Soviet and Russian intelligence service against the United States from 1979 to 2001. His espionage was described by the U.S. Department of Justice as possibly the worst intelligence disaster in U.S. history. In 1979, 3 years after joining the FBI, Hansen approached the Soviet Main Intelligence Directorate (GRU) to offer his service beginning his first espionage cycle, lasting until 1981. He restarted his espionage activities in 1985 and continued until 1991, when he ended communications during the collapse of the Soviet Union. Fearing he would be exposed, Hansen restarted communications the next year and continued until his arrest. Throughout his spying, he remained anonymous to the Russians. Hansen sold about 6,000 classified documents to the KGB that details U.S. strategies in the event of nuclear war, developments in military weapons technologies, and aspects of the U.S. counterintelligence program. He was spying at the sometimes as Aldrich Amos in the Central Intelligence Agency CIA. Both Hansen's compromised the names of KGB agents working secretly for the U.S., some of whom were executed for their betrayal. Hansen also revealed a multi-million-dollar eavesdropping tunnel built by the FBI under the Soviet embassy. After Ernest's arrest in 1981, some of these intelligence breaches remain unsolved and the search for another spy continued. The FBI paid $7 million to KGB agents to obtain a file on an anonymous mole, whom the FBI later identified as Hansen through fingerprint and voice analysis. So let's move to cybercrimes, hacking and cyberbullying. So I will present about the hacking and my member present about the cyberbullying. Hacking is a commonly used hacking definition is the act of compromising a digital device and network through unauthorized access to an account or computer system. Hacking is not always a malicious action, but it is more commonly associated with illegal activity and data theft by cyber criminals. But what is hacking in cybersecurity context? Okay, hacking in cybersecurity refers to the misuse of devices like computers, smartphones, tablets, and networks to cause damage to our corporate system, gather information on users, steal data and documents, or disrupt data-related activity. So this is example case of hacking. In 1919, the country was rocked by an unexpected bank robbery case. Aman Shah is an accounting graduate from Mara Institute of Technology (UITM) and was 24 years old when he committed this serious crime. He works at Hock Hua Bank and is an efficient and celebrate employer. Seeing his potential, his employer sent him to attend a computer course where he would learn various difficult computer skills. Aman Shah committed this crime by deceiving the bank negara management, where he used the electronic transfer system for funds and securities paid. These false instructions enable Aman to defraud Hock Hua Bank by transferring 1 cent from the bank to this bistro account. He managed to transfer money from customer at Hock Hua Bank by cracking the bank security code as a result of a computer course he studied.
Cyberbullying is bullying with the use of digital technologies. It can take place on social media, messaging platforms, gaming platforms, and mobile phones. It is repeated behavior aimed at scaring, injuring, or shaming those who are targeted. This is about case about cyberbullying. Okay, Megan Tyler Mayer, 2006. Okay, Megan Tyler Mayer was an American teenager who died by suicide by hanging herself 3 weeks before her 14th birthday. A year later, Mayer's parents prompted investigation into the matter, and her suicide was attributed to cyberbullying through the social networking website MyBest. Lori Drew, Maya neighbor and the mother of Maya classmate, was found guilty of cyberbullying in the 2009 case United States versus Drew, but the conviction was later overturned. Lori Drew was indicted and convicted by a jury of vice- violation violation of the Computer Fraud and Abuse Act in 2009. 2008 over the matter. Her her conviction was vacated by a federal judge on a post-trial verdict and on grounds that the Computer Fraud and Abuse Act did not intend to criminalize the conduct of which Drew was accused. The government chose not to appeal this post-trial ruling. First of all, my name is Safiyyah binti ZURAIMI, PID 2215C. Burglary. Burglary, also called breaking and entering or housebreaking, is a property crime involving the illegal entry into a building or other area without permission, typically with the intention of committing a future criminal offence. Usually, the offence is theft, larceny, robbery, or murder, but most jurisdictions include others within the ambit of burglary. To commit burglary is to burgle, a term back formed from the word burglar or to burglarize. Okay, next, this is about case about burglary. Okay. R versus Kelly, 1993. The defendant had broken into a house using a screwdriver to effect entry. When surprised by the householder, the defendant told him to unplug the video and then pushed the screwdriver into his ribcage. On leaving the house, the defendant was apprehended by police holding a video in one hand and the screwdriver in the other. The Court of Appeal held that the defendant became guilty of aggravated burglary when he used the screwdriver to put the householder in the stomach. It was held that the focus of Section 10 was used during burglary so that the screwdriver taken into the house became a weapon of offense on proof that he intended to use it for causing injury to or incapacitating the householder at the time of the death. Next, I will present about robbery. Robbery is the unlawful taking of property from another by force or threat of force. Without force or threat of force, robbery has not occurred. This is about case robbery. Okay. R versus Health, 1979. Two defendants entered the victim's house and stole her jewelry box from her bedroom. After having taken the book, they tied her up. They were convicted of robbery and appealed against their conviction on the basis that the offence of theft was complete when they took possession of the jewelry box and they therefore did not use force immediately before or at the time of stealing. The defendant's conviction for robbery were upheld. The whole course of conduct is considered as stealing, and appropriation does not immediately finish when the defendant's conduct meets the minimum essential requirements for appropriation. The the death should be viewed in its entirety, which comes to an end when the jury device is used. Next, reckless driving. Reckless driving is when a driver intentionally increases the risk of an accident by being hasty or impatient, wanting to save time. Disregarding, sorry, disregarding safety and endangering others on the road. Okay, next, this is case about reckless driving. HKSAR versus Lam Chi Fat. At about 1 p.m. on a day, it was raining heavily and the road was wet and slippery. The defendant was driving a goods vehicle with his wife on board. It reached the intersection of two roads, went out of control, crashed into the railings by the pavement on the left. Mount the pavement, hit the canopies and a lamppost outside the shops and came to a halt. His wife was thrown out of the vehicle, who died 3 days later. 7 pedestrians were injured and objects outside the shops were damaged. The speed limit was 50 km/h. The vehicle that the defendant was driving was traveling at about 40 to 50 km/h. The the passers-by could not hear any sounding of the horns or braking sound. There were no skid marks or grease stains on the road. The defendant did not sound the horns, turn on the hazard light, shout loudly, slow down the vehicle, or use the handbrake to stop it. Tests showed that the defendant did not consume alcohol and there was no mechanical failure in the vehicle. The defendant was convicted of dangerous driving causing death in the district court, and he appealed to the court appeal. And then this is about driving without a license. Driving without a license means driving a vehicle without a valid driver license or without having ever been issued a license. Driving without a license is illegal in every state. The penalties for driving without a license vary by state and the circumstances of the offense. Potential penalties include fine, jail time, vehicle impoundment, and points on your driving record. Case driving without a license. Ahmad Zulfendi bin Anwar versus Muhammad Shahril bin Abdul Rahman, 2022. Okay. On 15 December 2017, a road accident occurred involving the appellant, who suffered injuries when the motorcycle he was riding on collided with a motorcar driven by the respondent. Since the accident occurred at 2 a.m. and no eyewitnesses were present at that time, the court decided that the accept version based on the silent evidence such as the debris on the lane, scratch marks on the road, nature or damage to the respect vehicles, as well as the one that is more inherently probable would be the appellant's version of story. The sections court allotted a biality between parties at 70% against the respondent for being responsible for a collision and 30% against the appellant of contributory negligence after he was found to have been riding his motorcycle too fast. Both parties appealed to the High Court. The High Court held that since the appellant had ride the motorcycle without a valid driving license, roadtax and insurance at the material times, the High Court imposed against the appellant an additional 30% in contributory negligence, which resulted in the allowed liability between parties to change from the appellant's favors, or 70%, 30% to 40%, 60% in favor of the respondent. That's all for me. Now, let's move to our next presenter.
Assalamualaikum warahmatullahi wabarakatuh. I'm HAZWANA with Imam IZMAN, PID 22035. Next, I will present about white collar crime, which is embezzlement. Embezzlement means the act of taking or misusing money or property that has been entrusted to someone, usually by an employer or authority, for personal gain. It is a form of financial fraud. The cases in this title in the case in July 2021, Syed Siddiq was charged with criminal breach of trust and misappropriation of fund belonging to Parti Pribumi Bersatu Malaysia, where he on served as head of Armada Yacht Wing. He was accused of withdrawing 1.12 million without the approval of the Party Heads Council and misappropriating 120,000 from party funds. In addition, in August 2021, he faced two charges of money laundering, each involving the transfer of 50,000 into his personal account. The court decision on 28 October 2022, the High Court ruled that the prosecution succeeded in proving a prima facie case against Syed Siddiq, and he was ordered to defend himself and all four charges. On 9 December 2023, the High Court found Syed Siddiq guilty of all corruption charge, sentenced him to 7 years in prison, a fine of 10 million and 2 losses. He was granted to stay of execution pending an appeal. After that, I will present about organized crime. Is about human trafficking and drug cartels. Human trafficking is trade and business involving the illegal movement or migration of human beings, including illegal and forced labor activities. The cases of child molestation in Kuala Lumpur 2017. Such event in Kuala Lumpur was successfully dismantled and forced to work as beggars or used in other criminal activities such as stealing and smuggling goods. Most of the victims are children from families who are less able and trapped in these activities. The court creation as a result, several individuals involved in the recruitment and management of the children were sentenced to prison and fined. Next, the drug cartels. The drug cartels are criminal organization developed with the primary purpose of promoting and controlling drug trafficking operation. This group managed loan agreements among various drug dealers for the formality of some commercial enterprise. This term refers to the coordination of the production and distribution of consigned. The case of public prosecutor and Kamarul Shazwan Kemarasan bin Abdullah. First of this case involves charge under section 39B of the Dangerous Drug Act 1952, which related to drug trafficking. In the case, OKT left his home in Jelatong, Penang Towers, Kuala Lumpur in a SP5 car. OKT's sister-in-law that had been borrowed. Also coming together are SP3, SP4, SP7 and a son of OKT. From Jelatong, they stopped at R&R Tapa for a quick meal before continuing their journey. When the journey continued, all the passengers Hazwi and the OKT has stopped by the Sungai Buloh Bright restaurant where SP6 complained together with his official and members, then conducted a raid and subsequently found drug paraphernalia from the footrest of the front passenger seat, which is between the front passenger, which is between the bottom of the seat and the footrest of the car. The court declaration as OKT was charged with 2 charges under the Dangerous Drug Act 1952 in the High Court Shah Alam. There are 2 charges against the OKT. First charge that you on 14 September 2013 at approximately 12:10 am located in parking area restaurant Jijata Sungai Buloh, Lebuh Raya Plus from north to south, Petaling Jaya, within the Petaling district, within the state of Selangor Darul Ihsan, have distributed dangerous drug, which is a total of 44.4 grams of heroin and 18 grams of monocatalamorphines. Therefore, you have committed an offence under section 39B of the Dangerous Drug Act 1952 and punishable under section 39B(2) of the Act. Second accusation that you on 14 September 2013 at approximately 12:10 am were located in the parking area restaurant Jejantas. Next, I was explain about public order crime, public intoxication and prostitution. Public intoxication refers to a situation where a person is intoxicated in a public place, usually due to the influence of alcohol or other prohibited substances, thus disrupting public order, safety or causing a risk to himself or other. The case is the case PP vs Segar Ramugam Sepang Section Court 2022 on 17/1/2021 between 9:30 p.m. and 9:40 p.m. The complainant and his mother were watching television in their living room. Suddenly, the accused entered the house in a drunken state, and the accused insisted his wife Sarawati, anak perempuan Raja Singgam, and to hand over money to him, but the wife ignored the accusation, and the accused strangled and beat his wife. The court declaration is the accused has been accused of committing an offence as charged and has pleaded guilty. To begin with, the court has outlined the legal position that the court imposed a sentence under section 173B of the Criminal Procedure Code. Next, the prostitution. Prostitution is the sale of sexual service such as oral sex or intercourse, usually for money, but sometimes also for drugs, jewel or real estate. A person who prostitutes herself is called a prostitute. Most prostitutes are women, but there are also male prostitutes. Cases is PP vs Tyson, 11 July 2022. The accused has been accused in the Johor Bahru Criminal High Court of the charge of having committed an offence under section 130 H547, which is to have formed an organised crime group that is active in prostitution and sex exploitation activity involving foreigners to seek profit and to get material benefit. The court decision is the court decide that this sentence depends on the facts of the case presented by the prosecution against the accused. The court has held that a 5-year prison sentence is sufficient